government on ISDS cases, and is really coming at this with her sort of perspective as an arbitrator for the purposes of the conversation. And Michael Weatherley, who's a partner at Ashurst, he splits his time between Singapore and now Brisbane. He has been working in the international arbitration space for a very long time across sectors, but a big focus on construction and renewable energy, among all the other usual suspects. So with that brief introduction, I'm going to hand over to those that you are eagerly awaiting to hear from, Lucy and Michael. And I'll keep people letting people in the background, guys.
Great. Well, thanks so much, everyone, for joining on a Wednesday afternoon or morning or afternoon, depending on where you are joining us from in the world. Michael and I are super excited to be discussing this very important topic with you. You can see the slides here. We do want this to be interactive, so if you have any questions or comments throughout the process, please do speak up. Just because I have the slides displayed, I won't be able to see you if you put your hand up, so just go off mute and interject. There is no need to be polite. So the title of this topic, we'll come back to how we generated this title, but of course it's Show Me the Documents, which is a play on Show Me the Money, which may make all of you quite depressed, as I was when I realised that that movie was released in 1996, which is 30 years ago today. Well, 30 years ago this year. So if you didn't feel old before you started this call, you probably will now. And there's another Jerry Maguire reference down the track. You'll have to wait and see if you spot it. Here's our agenda for what we're covering today. We are cautiously confident that you can all read at this point in your careers, notwithstanding it being 5 p.m. on a Wednesday. So we're not going to read out the slides in any detail. They'll be circulated to attendees in due course. So one of the things we're talking about today, and that we're obliged to talk about in any conference session on international arbitration, or indeed any topic, is artificial intelligence and its impact on the topic at hand. I don't know how many, in fact, I assume all of you are at least dabbling in the murky waters of AI. What I find it particularly helpful for is to help with these sorts of non-confidential presentations. So I personally don't use it for my arbitrator work, but I do think for this sort of presentation, it did a fantastic first job of generating the problem. So you can see on the slide now, this is what artificial intelligence, ChatGPT, said when I asked it about international document production in international arbitration. And frankly, this is a pretty good job, a pretty good summary of what the problem is that it generated very quickly in a way that was certainly an excellent starting point. These were some additional points that Michael and I came up with based on our decades of experience, not access to the entire internet like ChatGPT, but our decades of practical experience in dealing with document production in international arbitration, both as counsel and as arbitrator. And so I'll be speaking today mainly in my capacity as arbitrator, although I still do some counsel work for the Australian government. And Michael also does arbitrator cases, but will be speaking mainly in his counsel capacity. And I know on the line we have very experienced arbitrators and counsel. So as I said, please speak up. But some of the problems, and I'm pretty sure I don't need to convince anyone on this call that there is a problem in document production in international arbitration, at least insofar as it relates to cost and time, because as we all know, it's often one of the most cost and time inefficient parts of the process. And some of the issues that come up are when you have parties from different legal systems, which is quite common in international arbitration. And what I've personally seen quite regularly is that even if you have two common law lawyers involved who theoretically should approach it with a similar prism, one side will put in 10 requests and the other side puts in 50 requests, and you immediately have a mismatch of expectations and length of Redfern schedules that you need to go through. I also have seen, unfortunately, increasingly cases where there is no voluntary production from either side in response to requests, and they just contest everything, including on privilege, and that obviously increases the time and costs. And let me now hand over to Michael to talk about some of the other problems that he's encountered in his practice.
Yeah, thanks, Lucy, and thanks everyone for joining. It's great to be here. Look, on the next point is who's actually drafting these requests. I think that is probably the source of some of the problems with it. And I'm sure the answer differs firm to firm, speaking from my own practice. Certainly a subject I would only entrust to a senior associate, then settled by me as the partner. It's strategic. It requires quite intimate knowledge of the case, and it has high risk factors. Especially, the risk of putting a tribunal offside with annoying, vague, irrelevant requests. So it does need delicate care. I'm sure many others on the call approach it in the same way, but we've also probably seen a set of requests from the other side where perhaps the same level of attention hasn't been given. And I think that tends to come about in a number of different ways. One approach that causes this is very junior lawyers drafting requests without adequate knowledge of the case, without adequate supervision. Sometimes I'm certainly seeing this much more in recent cases. It's painfully obvious that AI has been the culprit. They've been let loose without a sufficiently critical eye over its output. And the result, as you've all seen before, is requests which do nothing but increase time and cost for everyone concerned. And I think, though, even where care is taken, we've got to ask ourselves, as we do on the slide, is the juice worth the squeeze? In how many cases have you found a smoking gun? I think we've all had a case where, probably by virtue of the subject matter, there's maybe an information asymmetry between the parties, and there is a crucial need for document production. One area I've seen that is shareholder JV disputes. If you're coming at it, particularly from the perspective of a minority shareholder who might not have access to everything. But aside from those types of cases, how often do you find critical documents that fundamentally shape the outcome of the case? And I think if we're honest with ourselves, I would probably hazard a guess that on average, it must be in the single-digit percentages. I have had cases where a smoking gun's been found, but even some of those aren't a result of document production. One of my favorite cases was one where my client was telling me the other side's witnesses, he's definitely lying, just straight up lying. I was pressing him on the existing documentary record saying, which was a bit ambiguous, saying, "Oh, are you sure?" He said, No, don't look at that stuff. Look at this. He pulls out his phone and shows me all the WhatsApp messages with the other side's witness. Sure enough, they confirmed that he was straight up lying. That was an example of a smoking gun, but not a result of document production at all. Certainly, I can sympathise with the feeling of just not knowing what exists out there. And we're all zealous advocates. We yearn to do the best for our client and find any helpful documents that might exist. I don't have a problem with that. I think that's okay, but I think zealous advocacy often becomes overzealous advocacy. Kitchen sink approaches, fishing expeditions, insufficient linkage to the actual issues that matter. That's I think all I have to say on the problem.
And certainly leading on from that, one of the realities that we're all familiar with, whether as counsel or arbitrator, or frankly as non-lawyers living our lives, is the sheer volume and number of platforms through which we can communicate, which has existentially and exponentially increased the volume of document production. So WhatsApp messages increasingly common to be produced, and often some dynamite stuff in there, because maybe not a smoking gun, but certainly some important statements, because parties, for whatever reason, feel more comfortable conversing over WhatsApp than they do in formal email. Plus text messages, LinkedIn messages, Facebook messages, every different platform, they are now susceptible to production, which is obviously increasing the volume of materials. So
one additional one on that, Lucy, just while I think of it, is prompts in AI platforms. that arguably could be subject to a document request as well. What have you asked ChatGPT? What have you asked one of the other legal-based platforms? Is that privileged if you're a lawyer or not? Really interesting questions coming out, and I know we'll come on to AI in a bit. So
yeah, and my understanding is the nascent jurisprudence on that exact topic is that those prompts are not confidential nor privileged. Certainly, if you're going to an open source AI, it's different potentially if it's your own in-house one, but certainly everything else, and it's mainly in America we're seeing these cases come through. Yeah. So here's a graph for your entertainment and to keep you awake and to keep you focused on these issues from the 2021 Queen Mary survey, and you can see that this is where party or council would be willing to give up, 27% would be willing to give up document production. And I think the more important one thing there is it's the third highest, and the other two are not, certainly the first one, not controversial at all. The second one, I'm not sure if there was a distinction between Zoom hearings and oral hearings, maybe not, but document production is the number three point. And certainly in my discussions with in-house counsel over the years, going back to is the juice worth the squeeze point, is that many of them say they are willing to give up the 3% chance of a smoking gun in cases to save millions and millions of dollars in document production across their portfolio of disputes. So in terms of potential solutions, we've tried to be practical and pragmatic and helpful in coming up with potential solutions to what I hope we can all agree is the problem. So first point, it might sound really obvious, but nomenclature matters. So we should not be talking about discovery or disclosure. We should only be referring to document production, because when you sign up to international arbitration, you should be expecting a narrower form of document production that is not equivalent to discovery in the US courts or disclosure in the UK courts. I'm not even sure what it's called in Australian courts, because I do such little litigation. Disclosure maybe in Australian courts. In terms of draft procedural order number 1, I think that, well, I know that in my PO1s, they've become increasingly longer on document production, as I've learned from past painful experiences with document production requests. Every time something goes not as smoothly as it could have in document production, I try and not guard against it in the next draft PO1, but at least factor that into my drafting on the first draft of PO1 that goes to the parties. And I'll show you some sample language in due course when we get there. Generally, I find after the parties' document production submissions are complete through the Redfern schedule, I usually go back to the parties and say, just to be clear, I understand the parties are seeking directions from me on claimants' DP requests 4, 6, 8, whatever, and respondents' DP requests X. And I'd also say, if my understanding in relation to actual voluntary document production, because as you know, that's the tribunal's usually not copied on any voluntary document production. We only see the Redfern schedules. And I always have a potential Zoom CMC scheduled into the procedural calendar to discuss document production, because at least for bigger cases, it's not generally worth it in smaller quantum disputes, but for larger quantum disputes, it can always be vacated if not necessary, but I would at least have it in the calendar rather than trying to scramble to find time that works for everyone. More leading on from potential solutions to the problems is, and perhaps obvious, but make sure you've actually read the pleadings before you decide what is relevant and material. But the reality is that your decision makers, your tribunal, will not know the case as well as you do as counsel in terms of relevance and materiality. So make their life easier, make it easier for them to rule in your favour, give them specific references to your pleadings for them to look at, to anchor your document production requests to. Also, in most of my cases, inspired by the ICC terms of reference, which I see are being eliminated in the next round of ICC rules. I read that somewhere, but in any event, I still use list of issues in all of my cases, and I'll come to you in a second, Erica, just want to finish this. I include lists of issues in my PO1, draft PO1. Sometimes the parties don't want to do it, but if they can articulate the list of issues, then linking document production to the relevant issue that must be decided is extremely helpful, and burden of proof, which I'll come back to. But there was a question from Erica, which I'm super excited by. Erica, over to you.
No, that was actually an accidental hand raise. Sorry.
Oh, you got me so excited, Erica. That's all right.
Sorry.
That's your nightmare, for to be called on voluntarily for, non-voluntarily for document production.
I was trying to do a thumbs up.
Right, thank you. So moving on to the actual decision itself, I was discussing this with Michael when we were preparing for this session. When I first started sitting as arbitrator, I would occasionally, in the Redfern schedule itself, which is an annex to the procedural order on document production, try and give an explanation for why a request was granted or denied. And then I stopped doing that, in part because I look at what other more experienced arbitrators are doing, and they generally don't. They have language in their PO which says where a request is granted, then the requesting party's reasons are more compelling, and conversely. And so I just say granted or denied in that column, because I think if you try and give more detail, it just causes grounds for a party to apply for reconsideration that they didn't have the chance to comment on, unreasonable burden or whatever. And that is the other point, is that where there has been a bit of a ships passing through the night on document production, which unfortunately does happen despite my best efforts in PO1, and we'll come to that language in a moment, that sometimes, depending on how the pleadings have gone, by the Redfern schedule has gone, a party has narrowed its request, and the other side hasn't had an opportunity to comment on the impact of that request as narrowed in terms of unreasonable burden. So I have occasionally, depending on the case, I've done it in 2 cases to date, that the parties had leave for consideration only in relation to granted requests and only on the basis of unreasonable burden, because it wasn't something I had enough submissions from the party on. And in both cases, there was no application for reconsideration. Point number 7 is that I'm increasingly seeing parties asking quite aggressively, or I don't mean that pejoratively, but asking quite affirmatively for an interim decision or award on costs associated with document production. I'd be interested to hear the views of other people on this line as to how often such applications are being granted. I've heard anecdotally that it is slowly happening more often, but the default is still to wait to issue costs until further down the track, because the tribunal doesn't want to prejudge procedural efficiency or otherwise during document production, but perhaps at the end or now, if anyone wants to jump in and give their views. And otherwise, I'll hand over to Michael to comment on points 8 and 9.
Pausing for a second to allow people to rush in. Of course, happy to discuss all of this at the end as well. If we're moving on, number 8 is the potential for parties to limit or even exclude document production in the arbitration clause itself. The challenge with that, of course, is it's really difficult to predict in advance the disputes you'll be facing under the agreement, and whether in the context of that particular dispute you will want document production, and if so, what kind. So you don't see it a lot, but I can say that parties are trying. I have a multinational client whose in-house litigation team are almost exclusively civil law lawyers, and they hate document production, even the very focused kind. And part of that's, a natural aversion as civil law lawyers, but partly it's strategic. They're an energy equipment supplier. As you can imagine, from time to time face defect claims. And in their mind, they're always going to be the party having to disclose the majority of the documents, sometimes being very sensitive technical and design documents. So they want to shut this avenue off right at the outset in the document, in the arbitration clause. Now, it's relatively new approach that they're taking on this. I don't have the stats, but anecdotally, I'm hearing that they're getting lots of pushback from counterparts, probably for the reason I mentioned earlier. And it's also a bit of a double-edged sword for them. The facts of a particular dispute may require them to seek disclosure, document production of the owner's operating history, for example. How else are you going to make the argument that the relevant issue was caused by the owner's misoperation of the equipment? Do you really want to shut down the ability to get those documents? Where I think it probably ends up in the negotiations is a more constrained document production process, perhaps by reference, for example, to the Prague rules instead of the IBA rules, something like that. The next solution we've listed on the slide there is more artificial intelligence. I say more because, of course, we've had forms of artificial intelligence in document review platforms for some time. What I'm talking about there is the brave new world of generative and agentic AI. We'll come back to that topic in a bit more detail in a little bit. But Lucy, I know that's perhaps a good segue for your next slide.
So we went to AI to articulate the problem. So we'll also go to AI to articulate, at least in the first instance, the solution. And you can see, again, the strategies. And again, pretty good stuff, right? This all makes sense. That's similar to the points that we've raised. Michael and I have tried to be a little bit more granular in detail, drawing on our 2 decades of experience, but this is certainly a very good basic framework that AI has come up with in terms of things to think about to make your document production more cost and time efficient. And here is the draft PO1 that I use to the parties. Again, this is always the first draft, and I know there's different views from arbitrators as to whether the parties or the tribunal should prepare the first draft. And my personal approach is to prepare a detailed first draft that sets out what I consider to be the most cost and time efficient way to run international arbitrations based on my experience. But it's only a first draft, and the parties can and often do agree to amend the language. But you can see the sorts of things on here. Just point E, certainly in the quantum phase, if you're in a quantum phase, or if there's a big likely to be, if it's a big quantum, this is increasingly common to have an indication as to which requests are made by the experts as opposed to by the council. And you'll be unsurprised to hear that tribunals are generally, not always, more receptive to document production requests drafted by the experts, because they are saying, as independent experts, retained by the parties, but independent experts, that these are the documents that they think are relevant and material to the key issues on quantum. You can see I've also tried to limit the DP requests to 10 in total in square brackets. Sometimes the parties won't agree to it, sometimes they do, but I've tried to include that to avoid that ships passing in the night, one side puts in 10, one side puts in 50. And I have also I do include this language about the factors that I will take into account. In particular, paragraph D looked at what did you voluntarily produce, noting that document production always works better if there is some voluntary document production between the parties. And for me at least, that is a factor I will take into account in ruling on the contested aspects of document production requests. And burden and standard of proof is increasingly being referred to in other POs I see from other arbitrators. I have heard of cases where a tribunal will reject every request, not involving me, a tribunal will reject every request for which the requesting party does not have the burden of proof, if you know what I mean, that the requests rise and fall with burden. I personally think that's a little too black and white. I think there must be, every request must be determined on its own, in its own context, but I'm hearing that happening. So back to Michael to talk about this protocol.
Yeah, and this one we can cover quickly. I think it was just a final point to kind of just remember that we do have this Chartered Institute of Arbitrators protocol on e-disclosure in international arbitration. And I raise it just because it formed part of the PO1 in a recent case of mine. And this is Article 2 from that protocol. And a Roman 2, 3, and 4 are very familiar. But Roman 1 forces parties to think a bit more granular level in terms of specific search terms for electronically held documents and specific parameters in terms of file location, date range, individuals, etc. You're clearly assuming you're using some form of document review platform, which is often the case. And I must say, it did streamline the process in that case, where basically all of the documents were held electronically by sophisticated law firms, each using their own document review platforms. So perhaps just a reminder to think about that and whether that's suitable for your case as well.
And just one comment on that from the arbitrator's perspective. It will only help you with the tribunal to show that you're trying to produce narrow and non-unduly burdensome requests if you just say all documents between X date and X and Y date relating to Z. But if you specify the information that's in this Article 2.1, in particular the likely custodians, because as we all know, otherwise you've got to go through an entire server, and you can narrow that down to say these are the custodians, i.e. the email inboxes that you need to be searching in the first instance on this particular date, and that immediately makes it more narrow and thus less likely to be unduly burdensome, subject of course to the date range. So another extract, this one's from the Queen Mary survey, and we thought this was interesting in looking at how have you used AI in the past and how do you expect to use it? And of course, we're focused on document review, and you can see there's quite not that many respondents in the 2025 Queen Mary survey are currently using AI tools, but they expect that to change dramatically in the next 5 years, which is consistent with what we are seeing and hearing in our practice as international arbitrators and counsel, subject, of course, to the terrifying caveats of hallucinations. There was yet another article just in the news about another white-collar law firm in New York having to write a mea culpa letter to the courts apologising for AI hallucinations in their briefs, notwithstanding the various protocols and guidelines in place that are meant to prevent that from occurring. So back to Michael to talk about this very groovy slide.
Yeah, thanks, Lizzie. I'm conscious of time as well. I think we're supposed to keep to half an hour, so I won't drag you through all the detail on this slide. I also don't profess to be an expert on this subject, at least compared to my e-discovery colleagues. But broadly speaking, we are moving into a new era of AI in document production, consistent with how AI is developing in all sorts of fields. We've gone from this machine learning era where we're doing continuous active learning models, guided along by human reviewers to kind of narrow large data sets. Identify relevant responsive documents. And those tools are still part of the workflow, but now they've been significantly enhanced by natural language processing, large language models, generative AI, which are very much taking the efficiency and capability of these tools to new levels. And one of the things that's super interesting is you get a massive document population. It used to be the case that you didn't really get full insight on that document population until someone in the team had reviewed the whole lot or a good significant amount. That's changed. You can probe these document populations now with inquisitive natural language queries. You get an almost immediate sense of kind of the shape and tone of the population as a whole, topics, events, sentiment, areas of relevance for the issues. And so those insights are then really valuable to then shape your further exploration and shape also your document requests as well. You develop a prompt, you test it on a sample, you validate, you iterate, and then when you're comfortable, you can run a targeted search across an entire population to identify relevant documents. It's much more complicated than that. There's layers upon layers of QA and validation, but the process of reviewing, finding relevant responsive documents is changing at a very rapid rate. I'm just not sure our protocols, our PO1s, our existing practices are quite ready and adapted for this. And to be honest, I can see some people, and I'm not sure where I sit just yet, but people don't trust the output sufficiently. Kind of the thing I want to leave you with on this subject is it is coming, we all need to engage with it over the coming months and years to make sure we're, on the one hand, comfortable that it's being used in a way that ensures integrity of the process, but also not overly limiting ourselves so that we miss the opportunity to significantly reduce time and cost in one of the most painful, time-consuming, costly processes in international arbitration today. I think that's all we've got time for, but happy to stick around for questions. Oh,
yeah,
got to do this
few,
slide.
a few very minor ones, again, illustrating AI benefits. We asked AI to come up with the title for today's topic, and it was AI who came up with our show me the documents one, but you can see like all of these were pretty good, and again, something that you can use as a starting point. So I think this does illustrate the benefits of it. If you want to, and who doesn't want to do more reading about document production, obviously as soon as this call is over, you're all going to follow all of these links and sit down with a nice glass of Rioja, for those of us who weren't in Madrid, and read more about document production. And then I thought we'd finish with a rather pretentious quote that I came across recently, and I just thought, let's try and repurpose it for document production. But this is to some extent what I referred to my PO1s getting longer and longer, because I learn from what has happened in my other document production cases and try and cabin against it. So that was what this rather pretentious quote was. And here is my favorite quote, my favorite slide, the second and final Jerry Maguire reference for today. So we are bang on. Well, we started a little bit late, so we are bang on time.
Thanks so much, Lucy and Michael. That was super interesting. I think the highlights for me were thinking about how sort of AI is really rapidly changing and expanding the scope of how you can get through document production, but also thinking about how arbitrators and parties can buy into really thinking about how we can do things quite differently with limited numbers of requests, and being really clear about how the requests are going to be considered by the arbitrator to guide parties in doing that. I've heard about people putting document requests, like building them actually into memorials to say, almost like you might have details of particular in a pleading, but saying this is, giving a marked up version of your memorial, saying this is what we need documents on at the different points for key documents. And just, I think, I liked that example because I thought as an arbitrator, it really goes to the heart of, well, do they need to see documents on this particular issue? And it really brings that to life when you're assessing the request, when you can see it sort of play out through the memorials in that way. And for my own part, I've started seeing requests for document production cost orders. It's one of those things that if one side has been overwhelmingly successful, you can understand that there's more merit in it. But unless it's been very clear cut, it's generally hard to justify doing a separate order separate to the cost award. I guess the other piece of it is how long you're going to be until how long the timetable for the arbitration is going to play, how far away a final decision will be, really. Lucy, have you had any cases?
No, just one other point on that. It's also tricky when you ask for a document production interim costs order, you actually don't know how successful or unsuccessful document production has been, because you won't know until the party's next round of written subs, where they talk about this document that was produced or adverse inferences, etc. So that's another reason why, at least for me, I've been a little bit hesitant, because you don't have visibility as to exactly what documents are being exchanged. You only have one party saying, sometimes it's clear that one party put in 100 requests and, 90 of them were rejected. But if the 10 that were not rejected, if that turns up some really good stuff for that party, you won't know about it until their next round of subs. But I see Matt from White & Case, who was, of course, a co-sponsor of the Queen Mary survey. Thank you very much for the correction in the chat. I see there's a question from Matt.
Can't hear you.
Matt, I think you're on mute. I'm sorry, or at least I can't hear you.
Oh, sorry. Now can you hear me?
There we go. Yeah.
Sorry, my mistake. Sorry, thank you to both of you, and hi, everybody. I just had one question, Lucy, about something you said about reasoning and the reasons you give for either granting or denying document requests, because it occurs to me that if parties are going to get better, case by case in terms of how well they draft their document requests, I wonder what's the point of having wonderful criteria in the procedural order if the parties don't know the basis upon which their requests are granted or rejected?
Yeah, it's a great question. And so I try and, well, in the PO relating to document production, I give general comments that relate to the extent possible to all document production requests. For example, I had a case where one party consistently asked for documents exchanged between the parties. And so I had a general comment that generally you don't get those documents because they're already in your, or presumed to be in your possession, custody, or control. And the burden's on you to explain why you don't have access to emails exchanged between the parties, for example, server, etc. And similarly, if there's a general statement in relation to privilege, I'll put that in the general comment or anything that applies to lots of requests. But otherwise, yes, it is tricky. I take your point, at least for most of my cases these days, the Redfern schedules have a lot in them. There's been a lot of arguments put forth between the parties, both for and against the request. And so that is, to some extent, the learning experience for counsel. But I'm interested in that feedback, that if counsel would want more reasoning in that column, I've just seen the more experienced arbitrators not do it. And I've accepted for my own part that the risks of it outweigh the benefits. But I'm open to other views. I know there are other people on here.
I mean, my own personal view is that, I do give reasons, but they're not necessarily long, but they do identify where the request either fell down. It's true that if it's granted, then there's not much to say. But if it's not granted, I think that's when you need to give reasons. And I think to at least identify which element of, for example, the kind of the building blocks of a document request, I think is helpful. Yeah, and as I say, and I guess the question is if you write, I don't know, something, a document request that goes over 3 pages and to get just rejected, I just say I think it's difficult for them to isolate what they did wrong. That's the key issue there.
You raise the issue of contests over privilege and different privilege laws, I believe. Do you have any sort of experiences to share on how you can make the process of those battles over privilege in different categories of documents, or different, if there's multiple privileges that might apply, bring them forward rather than that becoming a battle at the point of disclosure?
When you say at the point of disclosure, you mean at the point of the decision making? Oh, the production, yeah. In the draft PO1, I have a paragraph on privilege log that if documents are withheld on the basis of privilege, then the parties shall produce a privilege log setting out what's in the privilege log, including the applicable law on privilege. I don't yet. It's a great question. There's probably a way to make it more efficient if you can front load those privilege points, but you often don't know, as you've identified in the question, you don't necessarily know what the battleground will be until those privilege logs are produced. I am seeing this happening increasingly often, and generally the tribunals will try and resolve the privilege based on all potential applicable laws. So they find the applicable law is English, but in any event, even if Russian law on privilege applies, the same result would prevail, because these applicable law issues can be very tricky. But there is no easy answer on that one. I know in some cases, I haven't had this yet, but you can have a third party to do the inspection of documents. I think Judith Levine did one of them very early in her career when she left the PCA. She was doing that a little bit, and I know the PCA does that in other cases. I have not yet used that in my cases as arbitrator, but it is increasingly common for these well-resourced large disputes with big law firms on both sides. They spend a lot of time and money on privilege, and the practical reality, if you have a 3-person tribunal, the chair will do the heavy lifting on your Redfern schedule. Sometimes the co-arbs get involved, but sometimes they don't. So you might have a team of 30 lawyers working on these document production requests that you'll have one person trying to decide, a 200-page Redfern schedule. So it is not an ideal system.
The same case that I mentioned that had the Chartered Institute e-discovery protocol had a privilege referee as well. It was the first time I'd seen it. I can absolutely see the value in it, as you say, for huge voluminous privilege questions.
Was the privilege referee appointed before document production began or after the dispute about privilege arose? Because, I mean, maybe if you knew, maybe that's the way to make it more efficient. If you know there's going to be a fight about privilege, appoint the third party early.
Yeah, it was after it was raised, so that's a good point.
I've had that once, a privilege umpire, and it was without prejudice. Without prejudice, privilege was the privilege in question, and so it was particularly important for the parties to have a third party looking at those documents and not the tribunal. Yeah.
It does delay the document production process. So if you have a procedural calendar that hasn't factored in a month delay to sort out privilege, then you might lose your hearing date. So that's always a bit tricky.
Yes. I'm trying to balance between how much you put into the procedural timetable that ultimately elongates the length of the dispute, to take all potential steps into account versus trying to have an efficient process that doesn't have too many steps, is the constant battleground. Well, with that, we should probably end this afternoon. Enormous thanks to you, Michael and Lucy, for your excellent preparation today and that great discussion. And thank you on behalf of the ICC Australia Steering Committee to everyone who has attended today. It's been great to have your participation. Thanks very much.
Thanks, everyone.
Thank you.